Good afternoon. I'm Yohnka, the Director of Communications and Public Policy at the ACLU of Illinois. And I really want to thank you all for taking time out of your day on this gloomy afternoon here in Chicago to join us for a discussion about abortion rights and access here in Illinois and across the country. As you can see, the Executive Director of the ACLU of Illinois, Colleen, Connell, is here with me now. And then in a few minutes, we're going to be joined by our colleagues Ameri, Klafeta, who's the Director of the Women's and Reproductive Rights Project at the ACLU of Illinois, and our Director of Advocacy and Intergovernmental Affairs, Khadine, Bennett. But before we jump into this conversation, a couple of notes just of housekeeping that I wanted to take up. First, we have live captions available for the discussion today. In order to turn them on, all you need to do is click on the arrow next to the closed caption button at the bottom of your screen, and then choose or select show subtitle, and you'll be able to follow along with those captions. The other thing I just want to note is that we are going to take questions throughout the course of today's program. And so if you have any questions, if the discussion spurs a question for you that you didn't ask in advance, don't worry about that. You can put the questions in the chat, which is located at the bottom of your screen. And we will promise to get to as many questions as possible as we go through the next 43 minutes or so. Obviously, there has been a lot that has happened around the issue of abortion rights and abortion access in the months since we first saw the leak and then the final decision in Dobbs versus Hope Women's Health, the decision that struck down the constitutional right to abortion that had been recognized for nearly a half century in our country. There's really a lot to cover. There's a lot that's been happening, and there's a lot that's on people's minds. So we're going to jump in and get started right now with, as I said, the Executive Director of the ACLU of Illinois and a longtime abortion rights activist, Colleen Connell. So Colleen, welcome.
Thank you, Ed. Thanks for the nice introduction that summarized where we are.
I wonder, I just sort of turn over the mic to you. I wonder if there's anything you want to say to this audience before we sort of jump in and talk substantively about where we are.
Well, the one thing I want to say to the audience is, quite frankly, thank you, not just for being here today, but for many of you on our RSVP list, for being here for 10, 20, 30, 40, and in a couple of cases, almost the 50 years that the ACLU of Illinois has been advocating to protect reproductive freedom. And it's really because of that long-term commitment to protecting this fundamental right that Illinois today has put in place so many protections of this freedom. When I started at the ACLU many years ago, the Illinois General Assembly looked a lot more like the Texas legislature or the Louisiana legislature than it does like the body that in the past several years has enacted the Patient and Provider Protection Act and the Reproductive Health Act, and has repealed the Parental Notice of Abortion Act, which was a throwback to those bad old days here in Illinois, where the General Assembly literally enacted a restrictive abortion or contraception law every year that it was in session. So big picture, thank you. Big picture, that sketch of where we are today really reflects the importance of continued advocacy and continued vigilance to protect this right. No more so today when we have the uncertainty that's pending because of the lawsuit in Texas, which threatens medication abortion, the saber rattling by Republicans in Congress about passing a nationwide abortion ban, and the concurring opinion of Justice Thomas inviting so many challenges to other fundamental freedoms, including same-sex intimacy, and even the right to use contraception. So right back at you, Ed. Meeting the weather with a little bit of sunshine about what we've done and a lot of gloom about what's lurking out there.
Yeah, there's a fair amount of gloom to cover here, cover all of us here. Wonder if you could just talk for a second about something that folks may have seen and sort of heard about in the last couple of weeks, I suppose, which is this idea of an abortion criminal defense initiative that the ACLU is working on with other organizations. And I wonder if you could just sort of briefly, I know it's really information, but I wonder if you could describe kind of briefly what that is and what it's intended to do.
So in a nutshell, this joint defense arrangement is an effort to make sure that all patients seeking reproductive health care, including abortions, and providers who provide reproductive health care have the legal counsel, the lawyers they need to defend their right of access or their right to provide medical care in the face of the attacks by states around the country, attacks that, as we've all read, really are trying to assert themselves, whether you describe it as cross-border or cross-territorial, but it's basically efforts by, for example, the state of Texas or the state of Missouri to enforce their restrictive abortion laws in such a way that providers in states like Illinois are intimidated into not providing abortion care. And so that women in Missouri, women in Texas, women in Louisiana feel threatened and too frightened of criminal prosecution or perhaps civil action to try to come to states like Illinois to get the health care that they need and that we think they have a right to.
So I'm going to invite Ameri and Khadine to come on screen and join us right now. But as they do, Colleen, I wonder, you touched on this a little bit, and I just wonder if you could just kind of set the stage again for people who don't remember. So what was in sort of the early days of your work here on reproductive rights? What was the work like in terms of on reproductive rights? Was it mainly defensive? Like what did that look like?
So what it looked like really was a hotbed of anti-abortion activism. At that time, Illinois was home to a number of national anti-abortion organizations. And in addition, the General Assembly contained none other than the notorious Henry Hyde, who started the bad idea of stripping away Medicaid funding for abortion care in the Illinois General Assembly, succeeded there, went on to Congress, and brought those bad ideas there. But when I say it was literally every session of the General Assembly that enacted restrictive abortion laws, restrictive contraception laws, laws restricting the use of assisted reproduction, I meant that. It was literally every year. And some sessions saw several bad bills get voted into law. And again, to sort of show, the broad sweep of history here, in those days, it was often a Republican governor who vetoed these bad laws. And then there were veto-proof majorities, anti-choice majorities in both houses of the Illinois General Assembly for much of the 1970s and 1980s.
So with that as sort of a background, I think one of the things is that, and we've sort of said this before, but the Dobbs really didn't come as a surprise here in Illinois. We anticipated this, And Ameri, I wonder if I could start with you just in terms of some of the protections that with the change in the legislature were able to be put in place in Illinois in order for, in order to prepare for the day that Dobbs actually arrived.
Yes, thanks, Ed, and thank you to everybody for joining us today. So it was no surprise, particularly when Donald Trump ran on a platform of putting judges on the Supreme Court who would overturn Roe, the direction that this was going to go. And also I'll note that at the point that the Dobbs decision actually came down, at that point, the Supreme Court had allowed Texas SB 8 to go into effect. So, which was, flatly unconstitutional. So nothing really was a surprise there with the Dobbs decision. Beginning in 2017, we've had a series of great laws that both contain legal protections and also very practical things to help people in this state access care. Starting with HB 40 in 2017 that removed the old trigger law that would have, brought back old abortion restrictions, Medicaid funding for abortion. The key law that protects abortion rights in Illinois was passed in 2019, the Reproductive Health Act, and that's what codified Roe essentially here in Illinois and codified all the good court rulings that we had from decades of fighting back in the courts here in this state. As Colleen mentioned, we repealed the parental notice of abortion law, which was the last obstacle on the books, and that came off effective June of last year. And then most recently, the Patient and Provider Protection Act that we'll talk a little bit more about. But in addition to these protections, we have very practical things that help people get care. Medicaid coverage of abortion, private insurance coverage of abortion. We've removed a physician-only restriction so that other advanced practice clinicians can provide abortion care. And we have laws that do things like allow pharmacists to dispense contraception and provide for 12 months of hormonal contraception. So it's a good mix of legal protections and access.
I wonder if you want to just say a word on these protections that have been put in place in recent years. The degree to which sort of what the atmosphere is in the legislature to sort of make these changes, the receptivity of proposals that expand abortion access in Illinois. How have you sort of experienced that over the last few years?
Yeah, and so apologies, you may hear a train in the background. I'm in Springfield right now, getting ready to continue our fight to make sure everybody has access to care. So I would say when I first started in the General Assembly and just thinking through the amount of time it took to get some of these protections, starting in 2010, I think when I was a fellow, some of these items that Ameri just talked about were on our wish list of things we would hope to get. And it took until 2017, and that was actually when it passed, not when we introduced it. And a lot of those bills, so House Bill 40, the Reproductive Health Act, the repeal of P&A, it got the votes needed. I think the highest number we got was, probably 63 votes. So as folks know, we need 60 votes in the House, 30 in the Senate. It wasn't overwhelming majorities at all. We had to really fight when we passed House Bill 40 to talk about the protections under the RHA. We had a lot of folks, pro-choice folks, were like, you guys just came last year about something. Is this really necessary? Is this actually going to happen? You all are just, the sky is falling. We're all good. We're Illinois. And I think what we saw is after Dobbs, a lot of people were like, I'm really glad we voted for these initiatives because we allowed for folks in Illinois who are seeking access to care to feel that in Illinois, their right continues to be real. Access is always an issue that we're continuing to work on, but as it relates to the law. And then for people who are coming to Illinois anyway, that need to have a state close to them or as close as possible was really important. And we're able to legally allow for that to happen. I think once we got to post Dobbs, where people really felt that, whenever we say it could go wrong, it can go wrong. The votes we saw for the protecting the PAPA bill, protecting provider and patient access was one of the strongest votes we've seen. That doesn't mean that we're done. I think a lot of it is to continue to put loving pressure on legislators who are pro-choice to take the extra steps, even if we're being if those legislators may not think there's a need, it's always best to do the protection on the front end than the back end.
And
So,
can I jump in real quickly?
please. Yeah,
I just want to lift up not only the incredible advocacy of Khadine and Ameri in both drafting and getting these affirmative measures through the General Assembly. They should really be taking a bow or a victory lap. But I also want to lift up, I've just looked at the attendees who are here today, and I really want to lift up the advocacy of people voting, prioritizing voting for people who are, or candidates who are pro-choice. I want to lift up the importance of those constituent contacts, whether it's writing letters or responding to our entreaties to call or email their elected representatives. Because as Khadine said, some of these votes were incredibly narrow, and the margin of victory was 1 or 2 votes. And we wouldn't have been able to push it over the top without that kind of support from the people on this call. And it's just really important that we shout that out, because we know we're going to need more of it going forward.
so let me go to Ameri first on this one. Ameri, we've talked about the work that was done pre-Dobbs. For a minute, then we get to Dobbs. Dobbs passes. Other states start to take action. I wonder if you could just talk for a minute about what you see as kind of the greatest threats then to care and access as the result of what sort of happened in other places and in other locales and jurisdictions in the wake of Dobbs.
Yeah, so I'll start with this summer, because the summer was really chaotic in terms of the legal landscape. Some of these abortion bans were taking effect at different times. There was a lot of litigation. So the bans might get held off, and then the appeals court might overrule something a lower court did, and the bans would come back. So it was really difficult to navigate the legal landscape over the summer. It still is to some extent, but a lot of the litigation has slowed down. For patients and providers, it still is very, very difficult. They are trying to manage the volume of patients who are coming from other states to Illinois. There are 13 states right now that have a total ban in place, and then a handful more that have anywhere from a 6-week to a 15-week abortion ban in place. 8 states have abortion bans that are currently blocked by courts. So care is still really severely restricted, even though litigation is ongoing. And I also will mention that it's a web of restrictions. So there may be a criminal law in place. There may be civil laws like Texas SB 8. People are trying to navigate a lot of different legal barriers in different states. So a lot of our work is outward right now, looking at what is going on in other places and what that means for providers in this state providing it care, for the patients who have to travel here, and what are the legal risks that they're managing.
So Khadine, go ahead.
Yeah, just to add to that, I think some of the things that we've seen and continue to see is fear. Just with each decision, everything people are hearing, am I still going to be able to have a choice? What protections do we have in Illinois? Even some of the legislators who voted on these bills in the last 3 cycles, they were confused about what does Dobbs mean for them and mean for people in Illinois. You had providers who are dealing with the chilling effect of, even if we're protected here in Illinois, what does that mean around our patients who are coming from other states? There was a lot of that question of what can be done. There is that knee-jerk reaction to do something, but doing the right thing to both balance the need to assure people that we're hearing the concerns that they have, but not wanting to over promise what could be done in this minefield of a legal post-Dobbs world, which, who knows what constitutional law classes are teaching now, but we still strive to draft legislation that could survive a constitutional challenge. And I think, as we'll talk about later on with what's happening around medication abortion, that chilling effect is still can still be there now, even with the protections we have in place. And I do want to just say that I think being a part of the ACLU of Illinois, we're in a very unique place. I remember, as I came in as a reproductive rights fellow, just listening to all of the cases that we were responsible or the laws that we were responsible for enjoining, and then undoing it on the books, then putting affirmative protections, and now putting other protections in place where that integrated advocacy approach of the litigation or the legislative approach or communications messaging, because I think none of these laws or none of these protections we have in place are real if people don't know that they're real, and not just providers, but also for the average person and average communities. So I do want to just say that we're lucky to have those tools at our disposal, which makes it possible for us to be the helping hands that we tried to be when the House post-Dobbs working group, they came together, because they know that we know not just the legal side of it, but also the legislative side of it as well.
Yeah, and I think that, you really make a point that it's so important to do all of that work together in an integrated way, given the reality that, there are people who just read the occasional headline or see the occasional story, and that fear that you talked about, Khadine, is really palpable for them and really can dissuade people from acting in a way that they might. I wonder, Khadine, if I can keep you going, because you talked about the post-Dobbs working group and you mentioned PAPA before, the Patient and Provider Protection Act. And that's a mouthful. And I wonder if I could ask you to sort of talk about, that process and what the legislature was really trying to do with that bill.
Yeah, I think the process starts with listening. So we spent a lot of time in part because of the relationships that we have with providers, both in the work that we do and on the legal end and the legislative end, but also partners in this work across the state, but listening to what they needed or what concerns they had, what fears they had. So I think that was a really important part of it. And also not just abortion providers, but people who provide the services needed for folks to get to and to leave their abortion procedure, especially folks coming from other states, partners like CAF and MAC. Then the other part of it was to try to figure out what's possible. Again, because we're the ACLU of Illinois, we have access to other affiliates throughout the country, a national organization, and then other partner organizations who are thinking about those things. So really thinking through what can be done and how can we do it in an effective way, which took a way longer time than the RHA, because again, it's well, we could do this, but that doesn't really pass the constitutional test. So it took that a while. And then talking with other partners. So legislators, folks from the Attorney General's office, folks from the Governor's office, the House and Senate, to think through what were folks prepared to do. And I have to give a lot of credit to Rep. Cassidy, who was the head of the House Post-Dobbs Working Group, and all of the staff folks who were involved, because it really was bringing together all of the list of possible things, testing it out, and then coming up with a package of things that would, one, clarify what existing protections we have in Illinois, increase access and capacity, because we're seeing more and more people coming to the state for care, and then providing protections for folks who are doing this work. And it's important to note it wasn't just about reproductive health care, but it was also about gender-affirming care, because we know that those attacks are happening on the abortion front, but we also see the attacks that are happening around gender-affirming care and the criminalization of parents who want to support their young people as they transition, for people who are trying to access the therapies and the care that's important for them. So and knowing and getting to a place where all three branches, the House, the Senate, and then also the Governor's office, they were committed to making sure that Illinois continues to be a place where people can go and access the care they need.
So Ameri, I promise I'm not going to ask you to read the legislation from beginning to end, but I wonder if you could just highlight a couple of the elements of from that bill that Khadine was talking about, just a couple of the things that you see as kind of being the most important.
Yeah, so this law is really a statement on making sure that healthcare that happens in Illinois is done according to our policy in this state, and not letting states like Texas or Missouri or anywhere else tell us what we can do here. So it attempts to put a wall around Illinois and the care that's being provided here, by limiting the ability of other states to come in with a subpoena or a criminal summons or try to extradite somebody for providing care. If somebody gets sued in Texas under an SB 8 style lawsuit, it makes it difficult for them to come to Illinois to go after providers in this state and enforce that. And then the bill also does some other things that are aimed at improving healthcare access in the state. For example, it removed some restrictions on birth centers so that they can now provide the full range of reproductive health care. And that's really important, particularly outside of Chicago, where people may be already traveling longer distances to get reproductive health care. So again, this is a good mix of legal protections and measures aimed at improving access to healthcare in this state.
So, Khadine, I wonder if I could go back. You mentioned the protections that are in the bill for gender-affirming care as well as abortion care. And I wonder if you could talk a little bit about why it was so important to keep those protections in, and if, in fact, what you're forecasting here is that we're going to see the same kind of efforts around gender-affirming care that we've seen around abortion care to block people from traveling to other states and things of that nature.
I mean, we're already seeing the criminalization of gender affirming care. I mean, I forget which state it is. It's all a blur of states doing problematic things where a parent who is supporting their kid who's looking to transition, that could be considered child abuse, where there are concerns about people who are providing healthcare services to folks who are seeking gender affirming care may face criminal penalties. So it's been happening for a bit. And, you know, folks who are trans and gender nonconforming are under attack at a high level. I mean, abortion providers and folks seeking care, they're under attack, but those folks are as vulnerable and in some cases more vulnerable. So, and it's not necessarily, it's still a place for some decision makers where they're not as comfortable talking about those kinds of protections as they are around protections for abortion rights, abortion care, and reproductive health care. So it's really critical for us as we're thinking about healthcare, reproductive health care, gender affirming health care. They fall under the healthcare bucket as things that should be accessible to all, regardless of somebody else's thoughts about what somebody should be doing with their body or changes that they would like to make or decisions that they would like to make about their bodies, about the care that their loved ones would like to have access to. And for us, because we are a multi-issue organization and we care about both reproductive rights and LGBT rights, it was really important for us to make sure that the language of our law would incorporate both things. And also in some cases, like protections for providers against discipline by other states, there's language that says if you're providing care that's legal in Illinois, your licenses can't be taken away, or you can have access to expedited licenses to provide care here in Illinois.
So let me say that in advance of this, when people ask us questions, there was one topic that I think probably got more attention than any other. And Ameri, I'll start with you, but Khadine or Colleen, feel free to jump in. Everybody has seen a headline or read a story or heard something about this case that's pending down in Texas. They probably know more about the judge than we do about any other district court judge in Texas who is considering an issue related to medication abortion. And I wonder if you could just talk about what that challenge is and sort of what you see happening there.
Yeah, so an anti-abortion organization has filed a lawsuit in federal court in Texas to try to force the FDA to withdraw its approval of one of the medications used in medication abortion. And they've sued in Texas because, you know, presumably they believe that the judge that they were able to draw there would be a favorable judge in this case. And it's a judge who's issued some conservative rulings in the past. Just at the outset, I want to be clear that this case could affect the supply of medication and the use of medication, but it does not change the fact that abortion is legal in Illinois and abortion will remain legal in Illinois, regardless of the outcome of this case. And I think this goes to Khadine's point that we already hear a lot of confusion from people about what this lawsuit means. So they've tried to sue to say that the FDA should not have approved one of the two medications that are commonly used for medication abortion for a number of reasons, including safety and a whole bunch of other reasons. And if this sounds to you like a dumb lawsuit because this medication was approved 20 years ago, and it's been repeatedly reaffirmed as safe by the FDA, you would be right that this is not a lawsuit that we would ordinarily expect to have legs. We would expect something like this to be dismissed. But because of concerns about the judge, people are preparing for the possibility that we could get an adverse ruling in this case. So the types of rulings that we could get. So the best case would be the judge just dismisses this claim. And like I said, people are not generally optimistic. The second best outcome would be the judge could not force the FDA to withdraw the medication, but the judge could put back in place some restrictions that require it to be dispensed in person, which has really negative and harmful effects for people who would have to travel to a clinic to pick up the medication. Telemedicine has really been a game changer in this area for people, particularly post-Dobbs. The third scenario is that the judge could order this medication, to be withdrawn if the FDA can't allow people to use it, but still leave open the other medication that is commonly used for medication abortion. And in that case, medication abortion would continue, but there would be a different protocol. And then really the worst case scenario would be the judge issues a very broad ruling invoking some 100-year-old federal laws called the Comstock Act that prohibit mailing abortifacients. And if the judge were to do something like that, it could jeopardize all medication abortion. So that's kind of the range of outcomes, which are not great. The ruling could come any day now. And so we're just waiting. After a ruling, it will likely go up on appeal. It would go up to the Fifth Circuit, which is also a very conservative circuit, and potentially up to the Supreme Court.
So a couple of questions, Ameri, that and others may want to join in. The first is, how widely used is this medication? I think people might have a sense, but just in general, how widely used is this medication for abortions?
It is very commonly used. It is widely used in this two medicine protocol. So this would have a very detrimental effect on the provision of medication abortion. The medication at issue is called mifepristone. The second medication that potentially still could be used is called misoprostol. It is also very, very safe. It is just slightly less effective. So that is why it is not usually the clinical first choice. But that would be the scenario there. But this is very common, and it's used early in pregnancy up to about 10 weeks. And like I said, it's been in use for 2 decades now. So,
right.
I don't know what else to say about the safety of a medication that's been in use for 20 plus years.
So let me ask a question I think Colleen will want to jump in on, which is another question we've got, and it's one that fascinates me because I'm the non-lawyer on this panel. Number one, how does the Alliance Defending Freedom have the standing to bring a challenge to a drug that was approved 20 years ago and been used? And how does a single judge in a case of ordering the FDA to withdraw it, how does a single judge from Texas have that power? I think that is something that as people read this, they really wonder about.
So I think in a word, perversion of both our jurisprudence and the medicine here. I mean, to your point, it's very hard to understand why a federal court, which has constitutional limits on what kinds of cases it can hear, including the need for the plaintiff to show that they were injured in fact, as sort of the threshold that they've got to cross before they can sue. And it's hard to see any injury to ADF other than an ideological injury. They don't like abortion, and I would say they don't like women. And they are very hostile to LGBTQ folks. And the courts have, for really, quite frankly, almost all of my legal career, ruled that an ideological injury is not sufficient to satisfy the Constitution's requirement for standing. And I think it's really important to go back and focus on what Ameri was saying about how safe these medicines are. They've been in use for 20 years, and really have been used in pregnancies without any serious complications. And to actually claim, as ADF does, that these medications are harmful to women, and that the FDA should never have approved them, and that the approval of MIFI should be lifted, is again a perversion of what the medical data shows, and a perversion of what people's experience shows for 20 years. And I think, Ameri, if I'm correct, roughly half of the abortions that are performed every year are performed with medication abortion. And it's been a game changer for patients, because it is less invasive. And it is something that many people can really actually manage without the kinds of transportation costs and inconveniences that have really been such a burden, or such a prohibition on accessing care, as we've seen more and more states restrict abortion rights.
So there was a headline over the weekend about Attorney General Raul from Illinois joining other attorneys general from around the state, or around the country, forgive me, in a different lawsuit that has to do with medication abortion. I will open this up. Can someone explain that one to me?
So the Attorney General of Illinois, along with a group of other attorneys general, has filed a similar lawsuit, arguing that the FDA's restrictions on the medication used in medication abortion are improper because it is so safe. So at the same time that we have this lawsuit proceeding in Texas, we're going to have a somewhat parallel lawsuit proceeding in Washington, which is part of the Ninth Circuit. So I think every day in this new world brings out a lot of questions, hearkening us all back to our federal courts and federal jurisdiction classes in law school. But I think we will see both of those cases proceeding at the same time. But that is, an affirmative case. And again, this medication has been subject to a lot of medically unnecessary regulation over the years. The in-person dispensing requirement was not lifted until the last year or so, but there are still restrictions that we don't see for other medications. Things like providers have to be certified. Some people may have seen that the FDA just opened it up so that places like Walgreens and CVS and other pharmacies can dispense the medication. They still have to be certified. Those are all medically unnecessary, and that's what is the subject of the challenge proceeding by the attorneys general.
So you've got these two different things kind of kicking along in the courts that could really have two opposite impacts on medication abortion in this country.
Exactly.
Yeah. Okay. I'm gonna go to a question that we got from one of our viewers here. And Colleen, I think I may start with you on this, because the question is that, given the example that some of the votes in the latest legislative wins were so close, and that so many people thought that Roe v. Wade was solid or safe, does it not show just how fragile laws are? And therefore, why is it that we shouldn't be putting attention into constitutional protections in Illinois? Does that track for you?
It does track for me.
Thank you.
I'm just going to say, advocacy at every level is important. We can't neglect, continuing to litigate in the courts. We can't neglect really continuing to be robust advocates in the Illinois General Assembly, and then, of course, the question of constitutional amendment comes up. And I think it is an option that we need to explore. Like I said, we need to explore all options. But I want to just lift up two caveats. One, I think, is probably really obvious to everyone, which is that if there is a constitutional amendment proposal put forth in Illinois, it is to protect abortion rights. It is absolutely essential. And I'm just going to yell that across the airways. It is absolutely essential that we win that vote, because it would be devastating in so many ways to actually lose that vote. So this is again one of those times that if that makes its way through the constitutional amendment process, it is really critical for everyone on this call and for all of our networks and all of our networks to make sure that this constitutional amendment would pass. The second issue that I want to really raise up, and this is the complexities of our federal system, and again, speaks to the need for advocacy at all levels, including congressional races and the presidential race, is that there is the supremacy clause of the United States, which says essentially that the US Constitution is the supreme law of the land. So if we were in a situation where, for example, Congress passed a right to life amendment, or perhaps even a comprehensive federal abortion ban, you have some very complicated questions about whether federal law is going to be considered the supreme law of the land and override state level protections for abortion rights. And so I'm going to say that the federal constitutional amendment process, as everyone knows, is even more challenging than the state constitutional amendment process, but we can't afford to disregard that threat, and we can't afford to really give up our electoral efforts to make sure that both houses of Congress and the President of the United States are pro-choice, because and supportive of LGBTQ rights. And really, quite frankly, the whole notion that it's an individual's protected right to make these fundamental decisions about who you love, whether you have children, how many children you have, or to quote from a kinder Supreme Court, to define one's own place in the universe without governmental interference. And so we simply cannot afford to ever think about accepting a constitutional regime in which, a federal ban on abortion rights or federal ban on same-sex intimacy or same-sex marriage is ever allowed to become the law of the land.
So, Khadine, we're moving really close to the end of our time together. I wonder what you see or what you think about what folks watching can do around these areas. And I really do want to ask a question. We are obviously sitting here today on the eve of, major primaries in Chicago tomorrow, and then a more widespread local elections in April in Illinois. And I wonder if you think that these issues are impacted at the local level and are things people should be keeping in mind about participating in those processes as well.
Yeah, you just teed that up. Look at me using a baseball reference too.
That's, you in sports, always together. Yes.
So voting, I think part of why we were able to get PAPA done with the votes that we did was because of organizations like, Personal PAC and others who really push for folks who are pro-choice legislators, and those people won. So, and they win because people show up at the polls. We know on the other side, they're organized and they're ready to cause more havoc. And I think it's really important for us to have our folks who care about these issues, both as it relates to reproductive rights, gender-affirming care, to show up at the polls. We're seeing at the local level, school board elections are a very scary place right now, where there are folks who don't believe in sex education, who don't believe in making sure that LGBTQ youth are affirmed, are running for election, and in some cases they may win. So those local elections are really important. I know whenever we have these things, I say it, and I think it makes a difference, but thanking people who supported all of these bills and now laws that we have in our state, and continuing to thank them and say that we want more when possible. So, you know, from the governor's office, the AG's office, and senators and representatives, I think that's really important as well. I mean, we have a bill, House Bill 3603, which is a bill to protect health data privacy. That was one of the things we didn't get done in the post-Dobbs suite of legislation. And this would essentially require companies that collect health data or offer health services in Illinois to increase the privacy protection that it affords the people who use their services. So having a health data privacy, getting a person's consent before they collect your health information, and then getting separate consent before they're able to sell, store, or share that data. And for folks, you know, when we were looking at post-Dobbs, the reality of folks, one of the big places was for folks leaving one state, especially a state that had some kind of criminal or civil problematic law, coming to Illinois. What happens to their data? What if they're found out? So that's a piece of legislation that would help in terms of limiting people's data collection without them knowing about it. So support legislation like that. So those are some of those things. And I just want to say, I see over and over again that the other side, whether it's witness slips or showing up for legislators or showing up for events, they're loud and they're also big in numbers. So I think, you know, we have a lot of organizing to do. It feels like we're a little bit behind, but I think folks showing up today makes a difference. Every time you click on the action alert or call someone, talk to your friends and neighbors, those are things that are really important. And you may not think it is, like, oh, what's the big deal? Do I need to? We hear from legislators when you do, and decision makers, and that increases our power in terms of making sure these issues are advanced and protected and continue to be a high priority for decision makers throughout the state and at local levels too.
Well, on this gloomy day, that feels like an uplifting point at which to leave us. And so I will close just by thanking Ameri and Khadine and Colleen for the conversation. Thank all of you for taking the time with this today. If you have a race to vote in tomorrow, I encourage you to vote if you haven't already, and to vote in April, and to keep voting, and to keep calling, and to keep responding to emails, as Khadine said, because it really does make a difference. And with that, I'll just say thank you all, and we will see you next time. I'm sure there will be another update on this topic.